to call the Crystal City Council meeting to order for November 21st. Let's start with roll call, please.
Councilmember Oneza Rosen.
Here.
Mayor Adams.
Here.
Councilmember Budashevsky.
Here.
Councilmember Cummings.
Here.
Councilmember Eidbo.
Here.
Councilmember Camish.
Here.
Councilmember Kaiser.
Here.
We have a quorum.
Thank you. Let's rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, we have an agenda before us, looking for a motion on that agenda.
Make
Therese.
a motion to approve the agenda.
All right, looking for a second. Go ahead, Forrest.
Second.
All right, all members in favor, please say aye.
Aye.
Opposed, say nay. Motion carries. All right, we got a couple of proclamations tonight. I'd like to read those into the record. Let's start with the Thanksgiving Day proclamation. Whereas the Pilgrims left England for religious freedom and went to Holland for more than a decade. Then in 1620, they set sail to the New World and landed where there was an abandoned native settlement with shelter, dried corn, food, and fresh water. The previous settlement was wiped out by what they believed was smallpox. And whereas Squanto, an English-speaking Christian native and survivor of the settlement, welcomed the Pilgrims and helped them grow corn and negotiate a friendly trade agreement or treaty with Chief Massasoit. That treaty lasted more than 50 years. The following year, after the Pilgrims lost half their population due to a brutal winter, 53 Pilgrims celebrated and praised God with 90 native warriors at a 3-day harvest fest, which is considered the first Thanksgiving. And whereas in 1641, the Plymouth Pilgrims passed a law designed to eliminate all slavery, which included the North Atlantic slave trade. And whereas in the spirit of President Lincoln in 1863, I'd like to thank God for our city leadership, including our entire council, our city manager, all the senior staff and the employees of the City of Crystal for the service they provide our citizens. Once again, we have experienced a year with great degree of tranquility, unity, and plenty. Now, therefore, I, Jim Adams, Crystal Mayor, invite my fellow citizens to set apart and observe the last Thursday of November as a Thanksgiving blessing and humbly implore God's protection and favor, dated this 21st day of November 2023. And the second proclamation refers to small business. Whereas creating thriving business climate is a priority of the Crystal City Council. Whereas the Crystal Council celebrates our local small businesses and contributions they make to the local economy and community. And whereas for many local residents, Thanksgiving holiday commences a season of gathering, dining, shopping, and experiencing arts and culture. And whereas public and private organizations across the country have endorsed Saturday after Thanksgiving as Small Business Saturday. Whereas the City of Crystal has partnered with Hennepin County in the multi-jurisdictional Love Local campaign, which encourages residents to support local businesses that create jobs, boost the local economy, and make our communities vibrant and livable. Now, therefore, I, Jim Adams, Mayor of Crystal, do hereby proclaim November 25th as Small Business Saturday in the City of Crystal. Proclaim this 21st day of November. All right, those are our proclamations. And before us, we have a consent agenda. I'll read that into the record at this time. The consent agenda are items which are routine and non-controversial in nature, and we approve those in a single motion. First item is approval of the minutes from the following meetings. The City Council regular work session on November 7th. The City Council joint work session with the Environmental Quality Commission on November 7th. And the City Council regular meeting on that same date. and then the city council regular work session on November 9th, 2023. Second item is the approval of the list of license applications submitted by the city clerk to the city council. That list is on file in her office. Adoption of a resolution making the city's annual insurance election. And then number 4, adoption of a resolution appointing a technical advisory committee representative to the Bassett Creek Watershed Management Commission. And then another one for the Shingle Creek Watershed Management Commission. Adoption of a resolution electing to opt out of the proposed settlement agreement with 3M and DuPont regarding the PFAS litigation. That is our consent agenda. Looking for a motion on that. Go ahead, Tracy.
I will make a motion to approve the consent agenda.
Thank you. Therese?
I'll second that.
All right. All members in favor, please say aye.
Aye.
Opposed, say nay. Motion carries. All right. Next is open forum. Open forum is a time where we ask citizens to come forward and speak for 3 minutes. We usually hold it to 10 minutes on each topic. We do have some, I see we have some, so if you could bring those up, we'll get started with open forum. All right, thank you. Dave Bison.
Good evening, Council. Thank you for your time and attention tonight. My name is Dave Beeson. I live at 6603 36th Avenue North. I'm here to talk about the CIC plat application. I'm opposed to the approval of this plat application and respectfully request that the Council deny it. It's simply not a permitted principal use in this R1 zone property, despite what the planner and attorney would like to have you to believe. Contrary to their position, the CIC plat would indeed be a division of real estate, creating units which are separate parcels. Real estate or parcel is not limited to land. Minnesota statutes define real estate to include, but is not limited to, interest in land, structures, or other improvements. This CIC would divide one piece of real estate into 3. For Minnesota 515B, in a condominium or planned community, each unit in its allocated interest in common elements constitutes a separate parcel of real estate. Further, the full text of 515B, not B1-106, not just the excerpt provided by the city's attorney memo, does allow a city to uniformly enforce its ordinances. The UDC is not invalidated by 515 as implied by the attorney. UDC 505, subdivision 51, provides a definition that a dwelling, one family attached, means a building such as a townhouse or row house containing dwellings in which each dwelling is located on its own parcel. Reminder, above, 515B, each unit is a separate parcel of real estate. Each dwelling is attached, B, each dwelling is attached to another by party walls without openings. And C, each dwelling has primary ground floor access to the outside. If this CIC plat were to happen, it would create one family attached dwellings because each unit would be its own parcel of real estate and they are connected by a common wall. Per UDC 515.17, Table 3, this would be a prohibited principal use in an R1 zoning district. As the city attorney stated, the city needs to process and act on this proposed CIC plat under the present language of the UDC. Let's do that. As a one-family attached dwellings would be created by this CIC and are prohibited principal use in zone R1, this CIC application must be denied. Respectfully request that the council deny this application. Thank you for your time and attention.
All right. Thank you, Dave. Kathy.
Thank you, Mayor. Thank you, council members. Thank you for your time this evening. And what I have to say this evening is just a friendly reminder and an encouragement to each of you. For the city charter, section 12.02, each council member subscribes to an oath of office which says that you will observe the provisions of the charter and ordinances of the City of Crystal, and will faithfully discharge the duties to the best of your judgment and ability. You're here this evening to hear from all parties on a matter, to be independent-minded and fair in your consideration, and to not be swayed by any person or side. Rather, looking to the facts of the ordinances of the City of Crystal, each member having one vote using their own judgment. I thank you for your diligence to be a fair and conscientious representative as you have been elected to be. Thank you.
Thank you, Kathy. Terry Barish.
Council, Honorable Mayor. My name is Terry Barish. I reside at 3541 Hampshire Avenue North in Crystal. I oppose the proposal to approve the Common Interest Community Plat. I oppose it on the grounds that the two-family dwelling on a single plat should never have been built in the first place. I oppose it because this won't make the problem go away for the nearby residents who are impacted by the decisions this council made, despite several objections from residents and from its own planning commission 2 years ago. I oppose it because it proves that the ends justify the means, even when several residents came before this council asking the council members and mayor to do the right thing. I oppose it because I watched as the mayor asserted his intent and will on the council through intimidation, citing imaginary legal obligations. I oppose the CIC plat proposal because I witnessed the mayor intentionally manipulating a council meeting agenda to juxtapose items for voting to favor a decision he wanted to push the two-family housing project forward. I oppose the proposal because a district court invalidated the decisions this council made to separate the lot in the first place. I oppose the proposal because the land was developed while ignoring the watershed and water drainage issues impacting the neighbors who live nearby. I oppose the proposal because from this day forward, the neighbors who live on and near the alley where this property is located will have no recourse to address the various issues previously identified and brought before the Planning Commission. I oppose the proposal because as I read the remarks from our esteemed city attorney and city planner, attempting to place blame for the situation on the very people who stood here in this spot, asking the council to consider the UDC. Regardless of the outcome of this vote, I'm saddened by this council and the mayor for forcing this issue upon the citizens of this beautiful and fair city when you had repeated opportunities to do the right thing. It seems like you have one more opportunity tonight, and I look forward to hearing that.
All right, thanks, Terry. Is there anybody else wishing to speak during open forum? Anyone else wishing to speak? All right, seeing no one approach, I will close open forum, and we will move on to our regular agenda. All right. Our regular agenda first item is expenditures $25,000 or greater. I will read those into the record at this point in time. Health Partners for November health insurance premium is $124,471. IRS electronic payments, federal and FICA withholding for pay date 10/27, $64,475. GMH Asphalt Corporation for community center parking for parking lot project for $74,396. Logis for our monthly application support and service hosting and fiber optics for $42,218. Valley Ridge Company for sewer repairs on Yates Avenue, $51,858. Flagship Recreation LLC for Welcome Park Play Area and Fitness Pod installation, $199,353. Odessa 2 LLC for Broadway Park trails, pedestrian ramps, curbs, shelters, and concrete, $116,235. min pair for employee city required contributions for pay date 11/9/23, $70,239. Total disbursements over $25,000 is $743,249. Let me try that again, $743,249.11. That is our total. Are there any questions on any of these items from the council?
It's a light month.
It's okay, I'm good with not spending.
Me
Was
too.
that sewer repair, was it a planned repair or was it a?
Mark?
No, it was not. So actually, that cost has been invoiced to the contractor involved.
All right. Oh, yeah,
Yeah.
that's right. Okay, any other questions? Go ahead, Therese.
I'll make a motion to approve the expenditures over 25,000.
All right, thank you. Taji?
I'll second that.
All right, thank you. All members in favor, please say aye.
Aye.
Opposed, say nay. Motion carries. All right, next is 6.2. This is the topic that we heard some comments on at our open forum. Our city planner is here for, to address the council on this. Dan Olson, welcome.
Yes, thank you, Mr. Mayor, members of the council. I do have a presentation tonight, and after I'm through with my presentation, the city attorney has indicated to me that he would like to make some remarks before you get into questions for me and for him as well.
All right.
So tonight, you're being asked to approve a resolution for a common interest community plat, which is commonly called a condominium, at 6613 36th Avenue North. Here in blue is the subject property along 36th Avenue, and the area in pink is the area where we sent notices to. We also posted the notice on all neighborhoods on Nextdoor, on the city website, and also in the Sun Post, of course. Here is a recent aerial photo showing the property under construction in 2022. Just a little general background. The applicant and property owner is JUF Enterprises, LLC, who is requesting approval of a CIC plat, or condominium, for a two-family dwelling at 6613 36th. The lot is addressed currently, or the legal description is Lot 5, Block 2, Gardendale Acres. It will continue to be one lot if this CIC plat is approved. The CIC plat will allow each unit to be sold separately, but it is not a division of land. The units would continue to be addressed as they are now, which is units A and B, and of that address. Here is a recent photograph of the property showing the completed two-family dwelling. Here is an excerpt from the CIC plat itself. First, there is what's called a site plan, just showing the building on the property. And then there is a floor plan showing the division of the ownership of the two units for the 3 floors. The recommended findings are that the proposed CIC plat is a division of ownership, not a division of land. Secondly, the UDC does not have specific criteria for approval of CIC plats that do not divide land. Thirdly, Hennepin County does not require city approval of a CIC plat, so under state statute, the applicant could record the CIC plat without city approval. The city attorney has indicated that state statute may preclude the city from denying approval of the proposed plat because it would be treating this development differently than other two-family dwellings. At the Planning Commission, which was November 13th, there was a public hearing held. One resident spoke at the hearing and had 2 concerns, which I will address here in the following slides. The first is that the first concern was that relating to building type. The resident stated that the building is comprised of 2 single-family attached dwellings, which is not allowed in the R1 district. The staff's response to this is that the building is not a single-family attached dwelling because each unit is not on its own lot, and that is in the definition of attached single-family attached dwelling. So that's why it doesn't meet that definition. However, it is defined as a two-family dwelling, which is a permitted use in the R1 district. The second concern the resident had was that the CIC plat is subject to local subdivision ordinance because state statutes do not invalidate city requirements. And along with that, the resident also stated that a new parcel is being created here because when the county assigns the PIDs for each unit, that person argued that was the creation of a new parcel. The staff response here is that the CIC plat only involves a division of ownership, not land. So the plat is not subject to subdivision regulations such as lot width and lot area, which are commonly looked at when you look at a division of land. So the other thing that I will note too is that the county will assign a PID to each unit, but this is an administrative tool for calculating property tax. It does not create a new parcels. Here's a couple of examples in the next couple slides. First of all, this is an example of the attached single-family dwelling type that the resident stated that this was. So this is called Memory Lane Estates. It's up on 42nd. You can see that these are two dwellings that are side by side. They each have their own lot, and so that would be considered meet the definition of a single-family attached dwelling. And then the other example I will note is just multiple units or multiple PIDs on one lot. This is a condominium up on Veracruz. You can see that this is one lot on the screen. So this would be very consistent and very comparable to what you're being asked to look at tonight on 36th. Just one lot with multiple PIDs on it. This particular example has 4 PIDs on one lot. So the Planning Commission recommendation, there was a tie vote, 4-4. So the application was forwarded to you without a recommendation. City staff and the city attorney recommend approval of the CIC plat. So as I said, tonight you're being asked to adopt a resolution to approve the CIC plat at 6613 36th. And
All right. Troy, would you go ahead, please?
Thank you, Mr. Mayor and Council. So some of you may not, or maybe all of you aren't familiar with CIC. It's common interest community. Basically, the law creates this multiple ways of owning property. So these can be anything from what would look very much like a traditional subdivision, where it's broken out into several lots that are owned individually. So they're separate parcels of property created, again, blocks and talks just like a traditional subdivision. There's cooperatives where land is divided up, but into leased units. They're not individually owned. The members have interests, or essentially shares in the property. And then I'm not saying that these are all of the different forms of ownership, but the one that you're before you tonight is the condominium form of ownership. You may be familiar, I mean, you can build a condominium. In some cases, folks will come in and take an apartment building and condoize it. You probably heard that term. You go back through and create individually owned units within it rather than a rental unit. It becomes an owned unit, kind of between the walls. That's what you own, and that's defined and given a PID number. And the statute does refer to it as real estate because it's subject to real estate taxes. But you're not dividing the dirt underneath it. The lot is still a single lot underneath it, but you're taxing each of those units. It could be 2 units, it could be 200 units. The point is each of them are paying property taxes on their units because they are identified as taxable units, but ultimately, again, the land underneath is not being divided into 200 different units. So what you have before you tonight is a little bit of an oddity the way the ordinance is written. Basically, it lumps all CICs, regardless of whether it's the more traditional sort of subdivision all the way to the condominium. It just says CIC. It doesn't divide it up in the definition of subdivision. And because we didn't fine tune it to indicate that these kind of real estate divisions are excluded, the owners are forced going through this subdivision approval process. There's really not a lot to this. Nothing changes. It doesn't change the nature of the use of the property. It's still a two-family dwelling before. It's a two-family dwelling afterwards. It doesn't divide up the property itself, the dirt. Really, nothing changes. It's an ownership change. Typically, as you know, the council doesn't get involved in owning or issues of ownership. I mean, if you want to sell your property, you don't run it, you don't approve a change in ownership that way. If you want to add people to your deed, you get married, you want to add a spouse to it, the council doesn't get involved in that. So this is essentially that. You're changing the ownership structure, so it can go from rental units to ownership units. Doesn't change the nature of the use under your code. So that's really the point of it. Staff did propose an amendment to carve this out, but that's the one that went through the petition process, and ultimately the council decided not to pursue it because it would have had to go to a vote, which would have been a little bit difficult because there were, 50-some amendments in there. Trying to put that on a ballot would have been interesting. But that was one of the changes that were proposed, to try to carve these sorts of things out. Because again, as the planner indicated, these sorts of things just go to the county for recording. They don't come through a subdivision process. So it does make sense to have CICs in your definition of a subdivision, but it should be more subtly divided up to say those involving the division of real estate, the more traditional sort of dividing up the land. But because our code currently doesn't make that distinction, here we are. But also, given the nature of the fact that you're dividing something within a structure and not the land itself, there really aren't any standards that apply to this in our code, because we're looking at more of the traditional, making sure the lots are wide enough, and there's frontage, and there's area requirements that are met. It just doesn't apply to this. So there really isn't anything to measure this by, frankly. It's just a change of ownership structure. So I'd be happy to answer any questions you have.
All right, questions? Therese?
Who would own the land then?
So it's, and the owner's attorney may be online too, but basically it becomes common element, so they own the units, and the rest of it is common ownership, so it's shared among the two owners. So there's joint responsibility to maintain it, that sort of thing.
Tracy?
Well, so if it burned down, who's gonna get the land? Like, how does that happen then in the future? Would they have to build another two-family unit and it's the same thing, or like who's gonna get the land?
Well, they still have, so typically in a condo, you each buy your own insurance. That covers everything from the walls in, and then often there's, again, I'm more familiar with larger condos that have an association that then buys insurance on kind of the rest of it, the common elements and the outside of the structure, that sort of thing. But I'm sure the owner's attorney can describe kind of more what they have in mind with respect to this two-unit condo.
All right, John, go ahead.
Well, I guess that kind of, my question is there an association involved with this plan of having this residence be a condominium?
Yeah, there certainly are documents that are required to be filed and as part of this. The thing is, the city doesn't get involved in that. You know, we don't look at rental agreements when you approve an apartment building. We don't get into, that's kind of the private property side of things. In this particular case, you're just, because it's lumped in with subdivisions, got to run through this process. But we really don't get into the weeds of who's gonna mow which part of the lawn and who's going to shovel which part of the driveway and all that sort of thing. Again, larger ones usually have an outside company that takes care of that, but with smaller ones, the agreements will divide up who's responsible for what.
Okay.
So
Therese?
if it's a joint ownership of the land underneath, how do they decide who's responsible for maintaining the yard around the house? That's the two houses, for example.
Right.
And it doesn't make any sense that they wouldn't own the land underneath the house.
Is that the weeds part?
Well, whatever it is, but if
Okay,
there's a fire.
hold on a second, hold on a second. I gotta stop you on that comment, that's not a true statement. I mean, there are trusts for affordable housing that use that yanked land technique to try to make it more affordable. It is used all the time where there's the improvements on the houses are either owned or rented out when they don't actually own the land beneath it. That's just a false statement. All right, go on.
So, Mr. Mayor, yeah, so those forming documents that I talked about will indicate who's responsible for what. And at the planning commission, the owner indicated that there would be a division, you know, you're responsible for that, or your driveway, your side of the lawn, the other person's responsible for that side of the lawn. And again, they could choose to hire someone to do the whole thing. I mean, the point is, we really don't get into who's shoveling which part of the sidewalk. It's ultimately up to them to decide how to divide that, and that's where those formation documents divide that up. So that's an agreement, basically, when you enter into these sort of shared ownership arrangements. That's why those documents are so important, because they prescribe what your rights and obligations are.
Forrest, go ahead.
I have a number of questions kind of in a row here, but number one is, could somebody, hopefully you prepared this, what is the UDC policy that is essentially kind of triggering this conflict, right? So is it that in R1 you can't have attached single family homes, you can't have townhomes? Is that the part of the UDC that's in conflict?
I can answer that. Go ahead. If you want to. The reason, I mean, what is the reason for the CIC application?
No, I'm asking, a lot of the comments that we've heard have essentially said, this type of use in, their proposal, their idea is that this type of use in an R1 zone is prohibited. Looking through the UDC, the only thing that kind of I found was that attached single-family homes or row homes aren't allowed. Is that pretty much it?
Well, those are not allowed in the R1, that's correct, but this is not defined that way.
I know, but that's their kind of their thought is that this, in their mind, qualifies as that. That is the argument, yeah. Okay.
That the resident.
And the idea that it is not a row home is that it's a duplex right now, correct? Its existing use is a duplex, which is allowed in R1, correct?
Correct.
All right, so its existing use is allowed. Or sorry, go ahead.
And these aren't on separate parcels.
Right. That's really hard for me to go along with, because in the state statute, it says each unit and its allocated interest constituents become separate parcel of real estate under condominium. So it's like, you say it's not a parcel, state law says it's a parcel. I mean, maybe it's different definitions of the same word, but that's not what I'm really concerned with. How do you parse that out?
Think of it as the division of dirt.
Right, but
dirt
real
is not
estate,
being
no,
divided.
I have never, I've never heard of real estate only being dirt. It's also improvements. Like, that's generally considered real estate as well.
Or it's just improvements.
Right, it's all of that is generally considered real estate, right?
Yes.
Yeah, and so just saying, well, when we think about real estate, because I guarantee in the next 2-3 years of my term, we're gonna have something that come in front of us about real estate that is an improvement based, probably. Things happen like that too. So, but that's not really where I'm just kind of trying to talk this out in my head, because so essentially its existing use is allowed, it's a duplex. Mm-hmm. The modification doesn't affect the use really, right? It's not gonna affect it's just essentially changing ownership, right? It's parceling out. And so since the conflict with the UDC in my mind is that we don't allow row houses from a physical standpoint, the current physical condition of that property, of the real estate, the physical improvement on the land is allowed, right? That's allowed. No, I don't think anyone's disputing that a duplex is allowed there.
Correct.
And so I don't see any way that we can, and I've thought about this quite a bit, where we could say that we can deny the CIC application without being arbitrary and capricious. Because that's a lot of what I'm hearing is, oh, well, this shouldn't have been there in the first place, this or that, or this or that. That's a very easy arbitrary and capricious thing to say, because we're not following a standard, we're based off something else, right? And looking at the state statute, the only way that we can pass an ordinance limiting or prohibiting CICs is if there's a shortage of low or medium income housing in Crystal, which I don't believe there is, or if it affects our eligibility for state or federal programs, which I don't believe it does either. So it seems like our hands are tied in my mind. So that's kind of and I just want to make sure that all makes sense in kind of my way I'm thinking about it. And I want to just be public because I know this is a pretty controversial thing, contentious thing.
If I may make a comment, something that I've heard as a planner for years.
Yeah, go ahead.
There's a general misunderstanding on the part of the public, just the general public, that a condominium is a building type. It's not a building type, it's an ownership type. This building type that's here was built as a two-family dwelling built on a single lot, and that is a permitted use in the R1 district. The creation of a CIC, which again is ownership related, does not change the building type. It's just a change to the ownership.
Yeah, that was my impression too.
Yep. Therese?
So when these two homes are listed for sale, is that going to be made well aware of?
Yes. Yeah. Yes.
This seems pretty
I mean,
unusual to me.
You have to list, they have a legal obligation to list what the house is and what covenants are around that house. Absolutely.
Yeah.
Go ahead, Therese.
Well, so I'm just still trying to figure out this whole, the land's not owned. So you've got two houses that are owned on land that's not owned. If the house structure, both of them burn down and they decide not to rebuild, who gets the land? Do they, I mean,
It's,
So, Mr. Mayor?
Yeah, go ahead.
So the land is owned. It's owned jointly. It's common element around it. So you own your unit, your individual unit. You're responsible for that individually. You have to insure that individually because this is your unit. So that's your own. You own within the walls of that defined unit. And then you have a common interest in the rest of it. And that's where those documents come in to say who's responsible for maintaining which portion of it, those sorts of things. So there is, if it burns down, then each of the units or owners are going to be able to make claims against their insurers to, just like if your house burned down, to have recourse to have it rebuilt. So it doesn't change, again, the underlying property is still owned. It's owned by those two unit owners commonly.
It's still owned and it still has value.
Oh, absolutely.
it would just be more complicated.
right.
Like if it all burnt down, it would be more complicated, but there still is ownership. It's just shared ownership through, I don't know, whatever legal instrument owns it, but, something that's
Well, so
shared.
to sell it, they'd have to both be on agreement that we're gonna sell it? Or could, the one could buy the other out?
No, I could sell my unit individually from your unit.
But I meant like with if it burned down thing and it's just the land.
Yeah, that gets worked out.
Yeah, that's the condition of a purchase, that they know that that's the agreement that they're stepping into.
It gets identified as a condo, and then those condo documents become part of the package that you have to review and be comfortable with, because you're buying into that package.
Yeah. That is very obnoxious. Are you guys hearing that out here? Okay. Any further questions? Anybody still foggy? I know the idea of land isn't a common thing. With a condo, at least with my perception of condo, it's real easy to see how there's a common ownership, and we see organizations designed and created just to manage that commonly owned land. But it doesn't require it to go that way. And I don't want to get into the minutia of what that agreement looks like, because whoever is going to step into that is going to be willingly stepping into that with their purchase agreement. All that needs to be kind of above board. It has to be all the way above board. But yeah, there are there are single-family homes that you can buy where you can't own the land. So there's a lot of different instances in real estate where that applies. It's not just in the affordable housing space. I know some real estate investors who really don't want to manage tenants, and their idea was yank the land. It's this investment, which I can't stand the investment strategy. They will sell the house, the improvements only, but they will keep the land, and they will charge rent on the land for whomever owns that into perpetuity. And it's just, it's one of those things that has been put together with affordable housing. At the end of the day, you don't get that appreciation of the land. You just have that improvement, the house improvement or whatever the living building type it is. That's your only appreciation. So there's a lot of different things out there in real estate. This does not, in my mind, seem unusual. Go ahead.
Me? Oh.
Yeah, sorry.
So as Forrest kind of laid out, nothing, the use isn't changing, right? The residents are gonna be the same. It's just rental versus owner. Wouldn't it make sense that having ownership would maybe be better for the neighborhood, as opposed to rental? I mean,
Well, that would be my opinion, but other people may have other opinions.
They can still own the unit.
yeah.
It still can be considered an ownership. They don't necessarily need to be renting the unit, right?
That's what she said.
Right, that's what I'm saying. So
It's gonna be owned versus rented.
right, so right now, as it
Oh,
is,
I
it's a
misunderstood.
rental, and changing the wording is really all it's going to do is make it be owned as opposed to rented, which I feel would be a positive thing for the neighborhood,
Yeah.
but maybe I'm missing something.
So, that's your opinion, that's my opinion. We share the same opinion, but keep in mind, unless it's a covenant in the purchase agreement that it has to be owner occupied at all times, it still can be rented.
Right.
So it goes either way, but if it goes the other way, it has to be rented, unless it's a owner occupied duplex, and half would be occupied. Go ahead, John.
Just from my personal experience, an example I want to give is like the very large homes that are on Summit Avenue in St. Paul. They're too big to be owned by a single person, so they've been turned into condominiums. So like for example, each floor is a condominium, and so they, of course, all jointly own the property. And so if there's any issues in terms of upkeep or whatnot, it's within the condominium itself that they're resolved. The other thing I wanted to talk about is I live in a neighborhood where there's rental property, and quite close to me. And, the homeowners that are engaged in the area are, been there for a long time. They make improvements to their homes or whatnot. I get to know them rather well. The people that are in the rental units they tend to keep to themselves. They pretty much, there's not much interaction between myself and them. I mean, I've, tried to, reach out to them, but they realize that they're only there for a short time, and they're more concerned about, an adverse effect, I guess, towards them or whatever. And so they don't have, they realize they're only there for a short term, and they're not really as engaged in the neighborhood as, people who own the property. So my preference in this case is, is always to have someone who is willing to be an owner of the property. They're long-term, you get to see their kids grow up, you get to talk to them, you get to become a part of the community. And that's my observation.
Therese.
I have a question. What you said, Jim, if it went the other way, what did you mean by that?
Went the other way. I'm sorry, I don't remember the context.
You said if it went the other way and it would be rented? You said it twice.
Oh, if it actually remained a duplex, it would be rented.
If it's a duplex.
At least half of it, the
Okay.
way it is currently.
So it could be the owner living on one side and renting the other
Correct.
side? Okay, okay.
And in a condo, you have a chance to have both owner-occupied sides.
Okay, thank
Yeah,
you.
That's all that meant. Yeah, Taji.
I have a question. So in our packet, a letter from a resident was provided. It just references a petition from last year. Can anyone provide a little history on that? I wasn't on the council at that time.
Yeah, please.
Yeah, so, Mr. Mayor and council, there is in your charter an opportunity for residents, if, once an ordinance is moving through and gets adopted by the council, there's a period of time, that's why it's 30-day delay before it goes into effect, is in that period, someone can circulate a petition to ask that before it goes into effect, it has to go to a vote of the residents at an election. So the city will typically, every year, every 2 years, come up with a UDC, you've probably seen it, a kind of a catch-all, make a number of tweaks, updates to the UDC. So that ordinance went through at that time, included a number of different changes, including that, trying to parse out that CIC, that these sorts of CICs wouldn't be considered a subdivision for the purposes of the UDC. That was one of many, many ordinance changes in there. And so then a petition was brought to stop that, because the council adopted it. And then, so within the 30 days, an appropriate petition was brought, or a sufficient petition, I should say. And then, so then it came back to the council to decide, do you want to move this forward to an election, or do you want to just repeal it? And so the council decided to repeal it.
So point of clarification, we just did a couple weeks ago, we did an update, right?
Yep.
It would be the same thing,
Okay.
except it was contested with a petition.
Got it.
Yep.
Mr. Mayor, just a point of clarification. So the amendments that were repealed last year were, there was many of them. They weren't just, it wasn't just dealing with this particular issue. There was dozens of different ordinance changes that were all invalidated, really, by the petition.
Right. All right. Any further questions? Do you need a minute to think?
Can I ask just a quick question?
Yeah, go ahead.
Is the structure currently occupied?
No.
Okay.
I have another question. How close is it to being completed?
It is completed.
Oh, it is, okay.
All right. Go
Is
ahead.
it not occupied just because it hasn't, like, why is it not occupied?
My understanding, but the owner is here tonight, he could address that, but my understanding is that he's waiting for this process to go through the CIC so he can record that CIC plat, and then he can sell both units to be owner occupied.
Go ahead.
Was this the intent all along? So,
No, the intent all along, it initially was a divided parcel. There were going to be 2 single-family houses. It came under contest. And what happened as a result of that is it became a duplex because that was allowed without any action from the city council. So that's what had happened. And it was built as a duplex, and here we are with the CIC. Does that help? Am I missing anything that you might, I don't know that, okay.
No. But I just would like to, I'm sure there's, just to put a fine point on at least how I'm thinking, you know, I know that there's a lot of people who wish this was never built in the first place, and I understand that. However, the action before us tonight is not something that could ever change that, and we just kind of have to follow the standard that's in front of us, because anything else would be conceived almost punitive and arbitrary and capricious and just be like an open, like, legal case for us. It'd be a lot of exposure, so, yeah, and so that's why I'm gonna be voting for the CIC application.
I'm right there too.
Is that
Go ahead.
true, Troy? Would that put the city,
Yes,
can you
Mr. Mayor.
talk about that a little bit, please?
Yeah, so I think during the orientation for when you get elected, if you recall, I sit down and I talk about different zoning decisions that you have, or types of zoning decisions, policy decisions, new ordinance amendment, change of the comp plan, those sorts of things. Those are policy decisions. That's vested with this body as a legislative body. A lot of discretion. Courts really can't step on your toes on that unless you do something completely out of bounds. They have to uphold that. When it comes to quasi judicial decisions, which this is, voting on a CUP, IUP, those sorts of things, it's just a matter of applying the law that's already been developed to the facts of the particular situation. So in this particular case, why both the planner and I pointed out there really isn't any standards. I mean, there's really nothing to judge it against. You can't say that it's not wide enough. You can't say it's too tall. You can't say, because there just isn't any standards to measure against. So I agree with the comments about if you were to deny this, it would be based on neighbor opposition, I guess. And the courts have been very, very clear over the years that neighbor opposition alone cannot serve as a basis to deny something. Because if that were the case, I mean, if you just have neighbors that don't like what you're doing, you never get it done. When in fact, if you're fully within the four corners of your ordinance, there's presumably have a right to do that. So that's where we're at, and that's why you typically don't see me, the city attorney recommends this when it comes to planning cases, because I just don't see any way for the council, and I don't normally say this, but I just don't see any basis on which you can say no to this. I just don't see it.
All right. Further questions? Seeing none, I'll entertain a motion.
I can make that motion.
All right, John?
Not on the right page.
I make a motion approving the resolution, a common interest community plat at 6613 36th Avenue North.
Thank you, John. Looking for a second. Forrest?
I'll second that.
All members in favor, please say aye.
Aye.
Opposed, say nay.
Nay.
Roll call vote, please. I'm sorry. What did you say?
I abstain.
You abstain, okay.
Buduszewski.
Aye.
Cummings.
Aye.
Eidbel.
Aye.
Hamish.
Abstain.
Kaiser.
Nay.
Oneza Rosen.
I abstain.
Adams.
Aye.
Motion carries.
All right.
Thank you.
Yeah, thank you, Dan. Thank you, Troy, for the help.
Thank you.
Next, we will consider the acceptance of the 2024 2000 to 2033 long-term plan. Our city manager is here to address the council, and we will introduce this.
Thank you, Mr. Mayor, members of the council. As part of our two-year budget process, the council reviews the 10-year plan, which is known as the long-term plan. It covers all long-term projects and capital funding. On November 9th, the council held an in-depth discussion of the revised 24 through 2033 long-term plan, and Assistant Finance Director Jody Bersheim is here as well. A couple of items I just wanted to point out that were included that were requested and included in the packet. You obviously had an updated long-term plan. There were just a couple small shifts and changes afterwards, but it didn't necessarily change anything as far as the overall plan. One of the other things that was asked for previously was the historical fund balance. We were able to get from 2005 to projected 2029, and so that was included as an attachment. And then the other item that was discussed was the projection of having a 10% levy in the out years from 2028 to 2033. So that's included as an additional attachment. What is being proposed tonight is what the rates that were discussed and gone over at the work session. The 10% projection is more for the council's information, and those decisions don't need to be made until 2028, presumably, if the council wanted to change something. It's well within their purview if the council wanted to make an amendment tonight, but that's not what staff is proposing. With that, if there's any questions, staff is available to answer them.
Questions? Any? So I'd like to I'd like to look at the 10% projection. Just wanted to make sure that, where is it? There it is. So,
Starting in 2028 is when the
10% kicks in?
the projected, if that's what the council were to do. One thing I'll point out is, as you can see, compared to the proposed long-term plan, it does escalate. That fund balance rate does go up very quick, or much quicker. It does get up, and in 2030, we're at the 45% of our policy, would meet our policy, and 48% of, based on the calculations under the OSA.
Yeah, and it puts us at about 35, well, not quite there on 28, but definitely there in 29. So that's basically 1 year.
2030? Yeah, it would just be resolved by the end of this decade.
Well, right.
Yeah, by the end of the decade.
But the only change to the what the long-term plan would be is in 28 essentially, and we'd have to come up with a minuscule amount to get to 35. That gets, well, of course I'm talking about the 35%, not the 45. It would just be another year for the 45, so 2 years.
So is what this saying is basically, based on the plan that we have now is, it looks like we're gonna get there anyways without having to, resort to, every year, putting forth a 10% levy? From 2028 on? Is that basically, is that reading it here? Because, it gets to the point where, right?
If you,
There's not a comparison here, is there?
no, there's not a comparison. If you open to page 9, 8 and 9 of the long-term plan book,
Thank you.
that would be the,
Comparison.
what would give you the comparison.
Okay.
So if you compare page 9, that shows that in 2027, it's still at 11%, but then the difference in 28 would be, as proposed, 8 versus the 10, and 29, 6 versus the 10, and so on. And then the percentages above that are the top one is the policy calculation and the OSA guidelines calculation.
Yeah, that's a completely different story.
Can I?
Yeah, go
I have
ahead.
a question here. Maybe I'm reading this wrong, but in looking at the 2033, for an example, line here in the proposed long-term fund, so the 7% levy increase, the total budget is about 38 million. And then looking at 2033 planned in the 10%, it's the same number. How is that? Am I reading that wrong?
I don't think so.
Sorry, could you state that again?
I'm like,
Looking at
it's two separate pages, so maybe my
Yeah.
rows got mixed up, but, so on page 9 of this document, under the column 2033, if you look at the actual budget, it's about 38 million. And if you look at 2033 column in the thing in our packet, just the sheet, loose leaf sheet, the 10%, it's the same number under budget? Is that just
Darren,
the?
are
you
the
looking
budget-
at
that's-
the
but that wouldn't
expenditure line?
change.
Because the transfer line is separate. It's
Yeah,
line-
the one below it.
The one below it.
So the budget's still the same, but we're transferring more money to the fund
Oh,
now.
so that's not, okay, so that's not actually our levy. That's our everything but.
That's the expenditures, and then the transfers out.
Gotcha.
And that's
So
why-
we don't have, on here, we don't have a line where it's like the total together, is there? I didn't see it, at least.
The total,
So essentially, everything that we're gonna have to levy for.
so what the, if you look at the budget in whole, I don't have the actual plan, but if you look at the revenues, the expenditure line plus the transfers out are your total expenditures.
Right.
And everything above that is the revenue that comes in to offset those expenditures.
Okay. So
And that
that's,
includes the levy.
so the property tax, comma.
The property tax,
GF.
general fund.
General
yes, is
fund.
that second line, so that's,
That is,
Portion of
that
the-
includes everything that we're expecting to levy for,
Yes.
or the general fund.
Yes.
Or
Does
the
not
g-
include the capital,
but does not include the capital.
yes.
Where is the capital in the revenue line?
This, that page that you're looking at is specific.
Typically
to
just for the general fund. All right, thank you. I wish there was like notes I could hover my cursor over and get a better, okay, sounds good. Thank you for the clarification.
And Mayor and Council, if you look at page 12, you'll see the total levy.
Aha.
I think that's what you were looking for.
All right. So, yeah, 1 year at 10 or 2 years at 10 gets us either at the 35 or the 45. So keep that in mind as you move forward into these next few years of budget planning. It's amazing. I think last time I said that it's amazing how much 1 or 2% can really get us to where we need to be. And my thoughts around this 10%, you know, once we put that into the budget, it stays in the budget. It doesn't go away. Now, there's a difference in the fund balance. Fund balance is a one-time expenditure. It's not a recurring expenditure except for whatever we increase for the budget. Make sense? We've talked about that a number of times. I hope it hits home. So then we can, as a city, we can reallocate that and kind of apply that someplace else if we desire. We can do that at the council level, or staff might do that. And that would be a great opportunity to kind of increase our ability to fund some of the capital that we're not currently funding. Just thinking out loud. Yeah, Forrest.
I brought up, like probably a couple months ago, the idea of having a different budgetary policy where, you know, every time the levy increased a certain amount, or our operating budget increased a certain amount, there was it would have to be, it'd be kind of complicated, but it's definitely doable, a calculator that would essentially spit out a number that would have to be added to the levy that would go into the general fund to cover that ratio loss in between operating.
You'd like to do that?
And I would like to do that.
I would too.
Just so that we're kind of, it's kind of automatic and it's,
Yeah, I think that is.
so, I don't know how you
Mark
fit
solid.
that into all this, but maybe next year we can work on that.
Well, that will be, we'll have to do that each year as we calculate this. This is what we're doing, you know, what's being proposed right now, obviously we're playing catch-up.
Right.
To get back to our targets. But that, as we go forward each year, we now know what is needed. And as each year, as there may be a change, you know, up or down, that number is gonna be different. But that is what we'll have to incorporate here.
Yeah.
Right now we're playing catch-up, so we're not adding, we're not at the point where we are adding extra. That's part of what we're discussing right now, to accelerate that. But this is now you know, we have these are all based on the assumptions at the beginning of the long-term plan. So if we're way off on our assumptions in 2 to 3 years, we're gonna have to update that. Those hadn't been updated on an annual basis, so we're gonna.
Yeah, I guess my point is more of by 20, so it's like, we're playing catch up right now. We're accelerating, we're adding kind of like 3-4 points to our kind of general fund kind of line, right, to catch up. But I can very easily see in 2030, when who knows who's still sitting here, oh wow, we're at it. We'll cut. We can stop doing that.
We can back off.
And we can back, and then we fall back into a situation. Whereas if you have something where instead of it's like, oh no, we know we have to do that. We'll do it every year. But whereas I'm hoping that if it was a kind of a more automatic policy that was just kind of baked in, then instead of saying, well, it's got to be 45%, maybe that would help. I don't know. I don't want to get to 2030 and then have this all happen again.
Right. I mean, I don't know if I had it my way, I'd bake it right into the plan today for those 2 years.
I'd be fine with those 2 years.
Gets us to a place where you found some rain. Is that what happened?
Yeah.
Okay, all right.
Yeah, my packet is drier. But, you know, I mean, I couldn't pull it apart until.
Oh, my God.
Pretty much now.
I'm so sorry.
Yeah, that still works.
There's a question down here.
Yeah, go ahead.
Yeah, we're talking about, you know, increasing the levy for a longer term, which I'm not fully opposed to, but I'm more interested in reducing expenses. And as I brought up in our last session, there are 5 park buildings on our long-term plan, all coming in today around $1.5 million a piece. So that's about $7.50 today. In 10 years, that'll probably be 10, 15 million. And so it's hard for me to be supportive of this plan when we are effectively planning for those large investments. I mean, the first one's coming up in a few years. I know our Parks and Rec Commission is exploring other park buildings in neighboring communities, trying to get ideas, and this is nothing against the Park Commission. I was on the commission. But I just don't know if our city is in a place to be investing over the next 10 to 15 years in structures like this. So I would be more interested, and I understand these are conversations we'll have over the next few years and whatnot, but I personally would prefer to not have those as a part of our long-term plan, and I think that would allow us to keep our levy lower objectively and still be able to meet some of our goals with our fund balance. So I think there's 2 different options, again, as we've talked about. You know, we can increase our revenue or we can decrease expenses. And so I just want to ensure we're exploring other ways we can decrease expenses as well.
And, you know, I think both. I like the idea. In kind of this long-term plan, we've taken some of those and stretched them out. Maybe we have to stretch them out much further. You know, it's not necessarily a cut to what our plans are. It would just be, you know, wait till it gets funded. You know, wait a longer period of time. But I really think because we're still sitting with some capital that needs to be funded, that there are going to be increases that need to take place as well. I used to be kind of on the yeah, let's cut some expenditures, but my gosh, I've never done that as a mayor here. Never have done that. You can look at this paper, and we've been expanding. It seems very out of character for kind of, I guess, my ideology and my political stance to be in that position. However, public safety is something that has had to have been funded at higher levels, and we did that. We did that both in personnel, equipment, buildings, the whole 9 yards, 10 yards, whole 10 yards. We're going the whole 10 yards. And I still think it's important to make sure we fund things properly. That doesn't mean, to your point, that we can have that many new buildings in that short a period of time. I agree with you on that. And it's not only those buildings, it's, are those the right buildings? Do they need to be? I think those conversations are yet to be had. I think you're right on. Yeah, John.
I just have a question. So I was looking through this and I saw a railroad repair. Is that the amount of money that we're paying to Union Pacific, whatever? And that's only a one-time payment of $7?
Correct, yeah, so the work will be done next year.
But it's only
75,000, yeah, it's just for the one crossing.
one crossing, and so it's not an annual payment that we make?
No, it's for actual work.
Yeah, and so they'll probably come back to us again sometime in the future with another.
Well, technically on that line, that's the only city crossing, the other two are county crossings.
Okay.
Hopefully not.
Well, hopefully not, all right, thank you. And then the other thing I noticed, I wanted to ask the Deputy Chief, I saw that you had $6,000 budgeted for 3 bicycles. I mean, those are some really nice bikes. I mean, so is that true? $6,000 for 3 bikes?
Point me towards where you are.
Oh, yeah, let me see if I can find it here in my damn plan, so, yeah.
24 and 25.
Thank you.
Here we go.
So, yeah, so it's budgeted for 2029. I suppose, given, bikes will probably be about $2,000 each.
Please, please.
At that point.
So we have 3 patrol bikes that we have. 2 of them were purchased in the last year and a half or 2. I can't remember the dollar amount, but I would believe that to be in the ballpark of what we've spent. The answer is yes, they're very nice bikes, as they need to be. Who knows, one, if we actually will need replacement by then, because they get used, but we don't get significant use out of them. And if we do need to replace them, do we need 3 of them? And do we, what's the cost gonna be to that at the time?
Okay.
So, if you're asking me, can you reduce that number?
No, I'm not
You
asking
sure
you
can.
that. I'm not- But I just think that's part of, what this long-term plan is that, I mean, these numbers are probably gonna adjust over time.
Yes, for sure, and I know, I believe this is true of all the departments, but certainly in the discussions that we've had in the police department, really, we've tried to identify a placeholder for what we believe to need to be the case on an appreciable value on whatever, and then guessing what a number would be based on whatever we have in recent history. So, that would be an example of the team put their heads together and went, well, we know we have one bike that's already 7 or 8 years old. We bought 2 bikes here. What are we gonna look like 8 years from now on that use, so.
Good, thank you.
Any other comments, questions? I got after thinking some of our longer conversations we've had the last couple meetings, I was thinking about how we got here. And there were a number of us who were groping for how did this happen and how did it happen so fast? And it occurred to me that when you're talking about going over budget, you go over budget 8%. That's the whole budget, right? When we look at the levy and how much the levy is funding, that's just a fraction of the budget. I didn't do any mental math, and I'm not about to start, but it's a fraction of it. So that whole 8%, when you apply it to the levy, becomes magnified. And that's how it happened. I think that just, if you think of it that way, you can kind of see how it happened so quickly. Because I think there were some questions as to what else, was there anything else contributing? Was it anything else contributing? And, you know, we were groping at capital and stuff like that, and, no, it was over budget. And I think it's just a reminder to all of us how important staying on budget is, because it does have that magnifying effect on what we're doing. So, just more musing by your mayor. All right, we have the plan before us. I don't know, is anyone else interested in baking in 2 years at 10% or not? Got 1, 2,
In doing what?
baking in 10% for those 2 years.
Until we hit 45,
Oh,
Till we hit,
yeah.
yeah.
but then dropping back down to maintain it. To what it's, so those 2 years, it'd be the 10%, and then going back to what's in here for those out years.
Then dropping the percentage back down, but not recapping what we increased,
Yeah.
because there's a difference.
Well, is it good, staying at the 10% plan that's in our packet until, what year is it?
2030.
2030, and then going, after 2030, going to what's in here? Is that what you're proposing?
I was, after 2030 going, I thought it was only 2.
Or just 3, is it 2 or 3 years?
It's 3.
2028 and 2029 are currently not at 10%.
So yeah, just those, so those 2 years, we do what's in the loose leaf, and then after that, we go back to the plan, the binded plan. Is that,
Yep,
okay,
Yep,
I'm okay with that.
and again, it's a plan, right? Is that doable for you guys?
Yeah, we can update that.
Is that something you want to bring back to us, or do you want us to?
I'm comfortable if the staff, or just so we're clear, so the current long-term plan in the booklet, the only thing that we would be changing would be in years 2028 and 2029 to have the projected levy increase to be 10%. And then the rest of it, 2030 on, would stay consistent with what is originally proposed.
I think that's fair, because we have those numbers built in if we fall short in 2030 to make up any shortfall. I think that's, yeah. Do we need to take a formal vote on that?
You probably should.
Maybe a good idea.
Yeah.
All right.
Yes.
So I'm going to make a motion to accept the long-term plan with 2 changes. One is to increase the unassigned fund balance amount, the levy increase to 10% for 2028 and 2029, and leaving 2030 on as it is currently in the long-term plan. Looking for a second on that.
I'll second it.
Forrest, thank you. All members in favor say aye.
Aye.
Opposed say nay.
Nay.
Roll call vote.
Cummings.
Aye.
Idle,
Aye.
Camish,
Aye.
Kaiser,
Aye.
Oneza Rosen,
Nay.
Adams,
Aye.
Budashevsky.
Aye.
Motion carries.
Thank you.
So is that amending this, or that's it?
That was passing it with
Okay,
those
good,
changes.
all right, good.
One vote.
Boom.
Next is the memorandum of understanding for law enforcement labor services. Adam Bell, our city manager, is going to address the council on that.
Thank you, Mayor, members of the council. Just bear with me one moment to get to my documents here. I made a mess, sorry.
Is it this? Use mine.
There we go. The, as we've done with some of the other bargaining units, the 2023-25 contract that was adopted last year with the LELS, Law Enforcement Labor Services, Local 56, included a reopener for insurance in 2024. And the sole purpose of that was to negotiate the employer's contribution towards the group health insurance premiums. As we've done as the council's done and it's approved the other items, the other reopeners for the insurance, this is the same as to be consistent with the non-represented employees as well as the other two bargaining units. So with that, I'm available for questions. The budget does include funding for these insurance. The insurance essentially did not change for the employee this year, other than the deductible did go up.
All right. Question? Seeing none. All right. John?
Make a motion to approve the memorandum of understanding with Local Enforcement Labor Services, Local 56.
All right, looking for a second. Tracy?
I second.
All right, all members in favor, please say aye.
Aye.
Opposed, say nay. Motion carries. All right, announcements. Office will be closed this Thursday and Friday, November 23rd and 24th, in observation of Thanksgiving Day holiday. Winterfest is December 2nd from 10 to noon at the Crystal Community Center. Next City Council meeting is Tuesday, December 5th at 7 p.m. Available via Zoom or in person. This meeting will include our 2024 budget and levy public hearing. City of Robbinsdale and Crystal New Hope hosting a Tri-City Parade on Saturday, December 9th at 5 p.m. I think that's where it takes off, so kind of got an estimate, since it's going through two towns, estimate what time it might arrive, starting in Robbinsdale, then Crystal, and then New Hope. Crystal Sparkles Holidays lighting map is available during the week of December 5th. Residents or businesses still wishing to share their holiday light display on the map can still register until December 3rd. Just go crystalmn.gov/sparkles. Meetings and work sessions are on file on our website for your listening or viewing pleasure. Just go to crystalmn.gov. Any other announcements from council? Therese?
I've got a couple. Dave Kaiser, no relation, CCX Media has had a crew putting together a video history of Crystal, and they've just finished segment one. They've been working on this for years. Hopefully we'll have it finished by the end of the year. So it's close, and they're just looking for places where it will be shown. So I contacted John Elham. Maybe it would be part of the Don't It Make You Wonder, what they do for seniors, and open up to ideas of anyone else wanting to see this video of Crystal's history. I know we're all on the edge of our seat, but it is really, really well done. So just putting up feelers there of anyone who, yes.
Is it going to be hosted online on CCX, or is it like a...
I don't know if I'm assuming it will be online. CCX has its own schedule. It will be shown there. They've done similar projects for Golden Valley, Robbinsdale, I think New Hope. I know they're working on Plymouth right now, so that towns that CCX or Channel 12 covers. So it's kind of, I saw the first segment last week, and it's really cool. So
Good. Tasha, you had a question?
Yeah, I think similar question, like, will it be available to can I go online and just look at it on my own time, or?
I'm assuming you will be able to.
Okay.
I know it will be broadcast some on Channel 12, and I'm assuming it will be available on the website. I don't know the answer specifically, but we're just looking, or David asked me to reach out to people to see if there's any organization that might want to see it, or any place that might want to be shown. And the second thing, we all got the letter from Hennepin County Commissioners Fernando and Jeff Lundy, I think he signed it, about the county's new zero waste by 2040. And this ties into the closing of HERC, the garbage burner, which has been operating for about 40 years. I was having a conversation last night with somebody I know very well who runs his team runs the business aspect of, they work for the county, overseeing the business aspect of HERC, and said he would be available for a work session if we have questions. I know him very well. I've been married to him for 30 years. So anyway, my husband runs that portion of HERC for the county. And would we be interested in him coming into a work session to answer questions about the future of HERC? Just an idea. I think we have until the middle of January to respond to the letter. Throwing it out there.
Is that going to be on a work session coming up, Adam?
We had not scheduled that yet, but we're also in discussion. I was going to talk about it in my constituent update regarding the organics. I'm meeting with Commissioner Lundy tomorrow to discuss that. So as far as part of the broader conversation, that's something that the council will need to discuss. That specific, responding to the letter that was sent out is kind of a sub-issue of that, if the city has a response. So we could do that. Let me ask, would the council like to schedule that in the next several meetings?
There's space.
Yeah. Okay. I will let you know.
Okay, you know how to find me.
Okay.
All right.
I know how to find him, so.
Any other announcements? Seeing none, looking for a motion to adjourn.
Over here.
John? So moved. Looking for a second.
Second.
All right, thanks, Forrest. All members in favor, please say aye.
Aye.
Opposed, say nay. Motion carries. All right, have a great Thanksgiving, you guys.
All right.
Wait,
Are we doing the work?
wait.